Good morning. Good morning, everyone, and a warm welcome to you this morning on a very wintry, cold morning. My name's Hilda, and I'm the Education and Engagement Officer at the Office of the Public Advocate. I've been at OPA for about 5 years. Initially, I started in the role of Advice and Education Officer, and now I'm in the role of Education and Engagement Officer. So thank you very much for joining us today. So we'll take a few minutes just to go over a couple of things so you know what we're doing today and how things are going to work. So firstly, before I get into it, I just wanted, of course, to acknowledge the traditional, the Victorian Aboriginal community and, of course, their rich culture. And I do this on behalf of my colleagues. We pay our respects to their elders, past, present and emerging. And of course, we acknowledge that their sovereignty was never ceded. So again, thank you for joining us today. We do have quite a few people that registered for this webinar. So we have 123. If your colleagues couldn't make it today, this session is being recorded. And following this session, I will send everyone a link to that recording as well as a PowerPoint presentation. And I trust that you've all received the resources that I sent you last week. So just a little bit about who's in our audience today. So we have a large group from the Austin. So welcome, a warm welcome to you. We also have people from Monash Health. We have people from Carers Victoria, and a big shout out to Carers Victoria as I used to work there. I also want to welcome, of course, some students that we have in the audience from La Trobe. So welcome to you. We have people from Eastern Health as well. Also from the Department of Health and Human Services, people from Victoria Legal Aid, Scope and Urella, and that's just to name a few. So quite a good representative of the sector out there. So this is the way it's going to work today. So we will have allocated question time. And I will encourage you to use the Q&A button for questions. So you can type in your questions and we'll take regular breaks to answer them. Because we have such a big audience, of course, we may not get through all the questions, but so I really encourage you to contact the advice service for any specific case consultations or specific scenarios that you want to discuss. And you'll see the number there at the bottom of the screen. I'd also welcome you to visit our website because we have a lot of resources, new resources specifically around the Act. I also, first, and now actually I would like to invite my colleagues to join me. So if they could join me on screen, Emma, Megan and Claire, there we all are, fantastic. I'm just going to introduce who you will be spending this hour and a half with. So firstly, we have Emma, and if you want to give a little wave, Emma, thank you. Emma Usher is our moderator for today, so she'll be taking care of the Q&A function. Just a little bit about Emma. Emma is the Legal Education Officer at OPA. I think she's been around for as long as I have, possibly 5 years. I think we started around the same time. So Emma's role includes assisting with OPA's legal education publications and very specific projects. So she has just started working on a project that's funded by the NDIA, and it's called Healthy Discussions, Supporting People with Disability to Make and Communicate Their Health Decisions. So if you sign up to our OPA updates, you'll receive some information about that, and you're also welcome to contact us if you're interested in being involved in that project or to find out a little bit more information. So Emma has a background in law, and before commencing at OPA, she worked in the Community Legal Centre sector. We have Claire McNamara joining us today. Now, Claire's been at OPA since 2005. She initially started as an advocate guardian and then moved into the position of legal officer in 2008. So she's been at OPA for a bit of time now. So Claire's work involves resourcing and advising us, so the OPA staff, about the legislation relevant to OPA's work. So Claire does a lot of our training internal to make sure that we're across various legislations that impact on our work. And Claire's commitment to community legal education really started during the years that she worked as a community lawyer, also in the community legal centre sort of sector. And finally, we have Megan. Megan Archer is our Principal Advocate Guardian. Now, she's been at OPA for 18 years, which I didn't know, which is a very, very long time. But during that time, she's had numerous roles across the office. Megan's background was initially in disability nursing, and early in her career, she worked in direct care and case management positions before coming to OPA. And now, so prior to being the principal advocate guardian, she was an advocate guardian for many years at OPA. So I think I just wanted to give you a bit of background as to who you're spending time with today. And I think I'm very comfortable and confident in saying that you are in very good hands. So today we're doing things a little bit differently, as in this is going to be a conversation facilitated by myself and also involving interaction from our audience as much as possible with the questions that you will pose. So I'm going to kick off, and I'm going to just stop sharing my screen. And I'm going to now direct, I guess, my first question to Claire. Now, Claire, this new act, so the Guardianship and Administration Act 2019, came into effect on the 1st of March of this year. And as you all know, what a year it's been. So we are all working from home still currently. So we're across Melbourne today. So it started the 1st of March. And of course, OPA's done quite a bit of work in preparation for this act. And then, of course, the pandemic hit just as we were getting into launching our education across various sites and across various organisations. We had to stop all that. So, Claire, we've got a big crowd today. So tell me, in your view or as your role as legal officer, why is this act relevant to health and community workers? Why is it important that people understand this act?
Yes, we wanted to explore this as an issue so that those of you who are listening don't say that this just sits with our office or with VCAT. Presumably all of you in the work that you do, you're very interested in promoting the human rights of people with disabilities. And that fundamentally is the main objective of the Guardianship Act. And we can go into some detail about that afterwards. But it seems to me that if you all understand the human rights discourse which underpins this new piece of legislation, then collectively we become a big group of people who talk about these issues in a way which promotes human rights. Because it's always been an interesting tension that for our office, that we consider ourselves a human rights organisation, and yet we're empowered to make decisions about people. And so there's always this tension between promoting rights, but also being empowered to limit rights. But it needs to be done lawfully, it needs to be done according to a process, and it needs to be done according to human rights. And so that's not just something that sits within one reasonably small organisation. That's something that for all of us who are committed to people with disabilities, we can all do something about. So that's sort of the philosophical aspect, but at the more practical level, and this might be why you're more interested in choosing to participate in this webinar, presumably amongst you, you often are in a position of making applications to VCAT for various appointments for guardians and administrators, and maybe now, because the Act allows it, also to make applications for the appointment of supportive guardians or administrators, which is a completely new part of the jurisdiction and might be something that I think we should find time to explore a bit further. And even if you've not made applications in the past, possibly you will in the future, no doubt you're often working with people who have guardians or administrators, or possibly people who have attorneys under powers of attorneys. So whilst we're not going to talk about the Powers of Attorney Act, nonetheless, there are some similar principles that relate to people who are empowered by law to make decisions for other people. So whether you're dealing with someone who's acting as a guardian or administrator for a represented person, or you're dealing with an attorney, you really do need to understand the scope of their powers, because it's up to all of us to challenge people using powers unlawfully and in a way that doesn't protect and promote the rights of people with disabilities.
Yeah, thanks, Claire. So this act, I mean, the previous act was from 1986, so it's been a long time coming. So there's a lot of information here, so I'm going to try and focus on some of the key points. But from where you sit, What do you think are the most significant changes in this new Act?
I think the most significant thing about this Act is that it explicitly refers to human rights. And it has been a very long gestation, this Guardianship Act. It's been the subject of review for many years and several terms of government. And many of the recommendations that came from the Victorian Law Reform Commission's investigation inquiry into guardianship, many of those recommendations had already been implemented through other legislation that no doubt many of you are familiar with. So the Medical Treatment Planning and Decisions Act, the Powers of Attorney Act, and the Mental Health Act. So the Guardianship Act is the last in that sequence. There's a quote in the second reading speech, I'm sorry I don't have to hand, but essentially what it says is that in the 1980s, when that raft of legislation, Guardianship Act and Disability Act, that was the era of deinstitutionalisation. And so many of those goals, it took some time, but the policy perspective of the mid-1980s played itself out over the next 20, 30 years. And now the next sort of phase, policy phase, is this human rights discourse. So whereas the other acts I've referred to really implicitly have human rights at its core, this is the only act and the first act to explicitly refer to human rights by reference to the Convention on the Rights of Persons with Disabilities. And so that's really significant because it plugs this local legislation into a more of an international framework of human rights. And also to come back to the point I was making earlier about this inevitable tension between, on the one hand, promoting people's human rights and yet a system which limits their rights, which is what VCAT can do when it appoints a guardian or administrator. That in itself limits somebody's rights. The things that all the rest of us, if we don't have guardians or administrators, we're free to make all our own decisions. As soon as VCAT appoints someone to make those decisions for a represented person, their rights have been limited. And so for that to be understood within a human rights framework is incredibly important. And hopefully, again, some of those things I'm alluding to at the moment we'll come back to and speak about again, or perhaps be informed by the questions you have. But perhaps the most important phrase that appears in the new Act is the expression will and preferences. So many people would be familiar with the expression best interests, the idea that a substitute decision maker makes a decision in someone's best interests. It would be in my mother's best interest if she lived in residential aged care. It would be in my brother's best interest that he was signed up for an NDIS plan. So that's the language people use, but the new Act doesn't refer to best interests at all. It talks about trying to give effect to the decision the person would make if they could themselves, but to give effect to their will and preferences. And it's a bit of a tricky expression, will and preferences, because it's not defined in the legislation. And certainly in the lead up to this Act, our officers had to give considerable thought. We've had many discussions about what we think will and preferences is. We've had to consider academic literature because that's really where it comes from. But the expression will and preferences does come from the Convention on the Rights of Persons with a Disability. To make things slightly confusing, in the Medical Treatment Planning and Decision Act, it talks about values and preferences. But you see similarly in that Act, there already was a parliamentary direction towards human rights focused legislation. But to reiterate, it's the Guardianship Act, which is the one which explicitly refers to the Convention. And so I think from my point of view, often when I do community education, there can be lots of detail and you will forget the detail. If there's one thing that would be great for you to remember, if you bumped into me, you'll recognise me, I won't know you, but if you were to say to me, I watched a webinar, the one thing I want you to be able to quote back is that you understand this is sourced in human rights. Because I feel if you come from a human rights perspective, even if you don't know the content, you're most likely instinctively to get there. If that's your first footstep, you're more likely to get there. If your first footstep's still in a paternalistic model of best interest, you are more likely to go off course.
And I find it interesting that you say that, Claire, because I remember when I started at OPA and I met you, and that is the one thing that really stuck in my head, that whole, moving away from that paternalistic best interest and really focusing on human rights. And if you do that, and I really believe this, then you can't go wrong. But I think what you're saying is that there has been a significant paradigm shift. And it sounds to me that you're talking a little bit about supported decision making. So can you talk a little bit about that paradigm shift that's occurred in the legislation?
Yes. So firstly, I would separate out the idea of supported decision making into at least two components. Other people will look at this in a different way. But firstly, what the Act does is allow VCAT to appoint someone to be a supportive administrator or a supportive guardian. So that's a new area of jurisdiction for VCAT. And there have been a few appointments so far that I'm aware of. The idea of a supportive guardian or a supportive administrator is not that they have power to make decisions for someone, but they support someone so that that person can make the decision. So the difference, so a person, if they have a bit of support, it might be they now have the capacity to make decisions. So that's an order that VCAT can make. And whilst that seems significant when you look at it in the Act, from my point of view, that's a lesser significant part of supported decision making. The more important bit has a much broader ambit. It's the idea that if people with disabilities were provided with practicable and appropriate support, they might be able to make decisions for themselves. They might have the decision making capacity to make decisions that in the past we've leapt into applications to VCAT, and VCAT's made orders. And really, if the resources and the attitude had gone towards supporting people, it might be that their rights never needed to be limited to the extent that they had been. So this issue of providing support isn't about what VCAT does. This is about what all of us do. And so one of the things that I've looked at recently, because the Act makes very clear that if you've got functions and powers under the Act, then you need to be considering how you can provide practicable and appropriate support. But the Act doesn't apply to everyone. So I began to think, well, how is it relevant? How, from a perspective of our office, can we advocate to health and community workers that they should be providing practicable and appropriate support? So being a lawyer, I went to the law, and I found in most of the principles of the key legislation I've referred to, I think so far, the Mental Health Act, the Disability Act, the NDIS Act, aged care principles, they actually all do talk about that people should be provided with support. So if you're in a position of thinking that maybe somebody needs a guardian or administrator, before you launch into an application to VCAT, you should be thinking, I wonder what support could be given to the person that might mean they have decision-making capacity. Now, that's not to suggest that most of you haven't been doing that already, but one of the things in our office's investigation program, I guess historically we've always focused on that. Could the matter be resolved less restrictively than by the appointment of a guardian? Or indeed, on our advice service, often people might be saying to us, oh, a person's got a disability, they can't make decisions, and we challenge that. Why can't they? How are you supporting them? The presumption is that they can make the decisions. You need evidence that they can't. Now the onus is on you to think, well, what else could I do that might mean they do have capacity? Maybe I should spend more time, if you're a GP, maybe a 15-minute appointment's not long enough. Maybe you need to see somebody more than once. Maybe you need to make sure they've got a support person with them. Maybe you need to provide information in different formats. And all of this actually goes back to discrimination law, and there's nothing new about this. The Disability Discrimination Act is 1992. You need to make a reasonable adjustment for a person with a disability. So I think this area is very exciting. Certainly in our office, we've spent a lot of time talking about this. We've had a particular group, we've had somebody facilitate discussions, and when we get to the stage where Megan gets to say something, she'll be able to give you some practical examples about what people in our office have been doing or what we're learning from what people in the community are doing. So what I wouldn't want people to think is that supported decision-making is just an application you put into VCAT and then VCAT appoints someone, because we won't know until some time has passed, and there can be some data analysis about how often people make those applications or how often those orders are made. But all of us, in working with people with disabilities, and after all, people with disabilities is not a small group in the community. I think the ABS statistics are 20% of the population has a disability of some sort. all of us are working with people all the time who have different levels of ability to understand things or communicate things, and the onus is on all of us. It's not about outsourcing it to a tribunal to make appointments. So, you know, over time, hopefully we'll all get really creative about that, and we'll share our creativity, and we'll really make a difference to the lives of people with disabilities.
Yeah, thanks, Claire. So I think, and now, I mean, as you know, we had all these plans for education, and we're slowly getting back there despite the pandemic. But do you think this is going to be a significant cultural shift for workers in the sector? Because as you said, I was in the advice service for 2 years, and I'd often get calls from, you know, workers in hospitals, really keen to head down the VCAT path, and in some cases without having even met the client, and that was not uncommon. So do you think this is going to take some time for workers in the sector to understand that there has been a shift here?
I think it'll take time, and that's only natural because, you know, it's a shifting in thinking about things, and also the language that you use. I'd say the change really has already been happening because we knew this legislation, you know, eventually was going to get over the line, because we had, from the time it was passed, we knew the commencement date. Certainly in our office, people started using language differently, and we noticed that VCAT members started anticipating the new Act too, and I think people in the community and the health sector did as well. But if I can make a point about terminology, because there are different words in this legislation, and one of the things a colleague asked me fairly early on is, when we talk about will and preferences, is it just another way of saying best interests or wishes? And from a legal perspective, what I'd say is, no, it's not, because Parliament wouldn't introduce new words if they didn't mean it to be something different. So, but what we've got to be careful about is that we don't then just, from a linguistic point of view, instead of me saying, now what are somebody's wishes, now I say, well, what are their will and preferences? If I'm not actually doing the deep work of trying to understand this concept of will and preferences, then the change will be much slower. I think if we have a really genuine engagement and curiosity about what life is like for the particular person we're dealing with, what they want, how what they want has been shaped by their circumstances, how what they want could be shaped by different circumstances, then we might start to see some changes. And of course, this piece of legislation is not a standalone thing. It's harmonised by many other initiatives that have been going on. I mean, it's quite a long time now since the Charter of Human Rights was passed, but that's now become cemented into the Victorian legislative framework. In the early years, it wasn't necessarily going to be a piece of legislation that continued, but it is. I think it'd be very hard to take it away. And also the NDIS Act, and whatever complaints people might have about the way the system has been rolled out, the failures of it, nonetheless, in principle, it is about trying to provide practical support to people for them to live the life that they want. And so I think there are many things coming together, but so I think using the correct terminology is really important, but also trying to reflect upon what you think this issue of will and preferences is. And I think we've got a slight point of parallel, which is that with the Medical Treatment Planning and Decisions Act, that started in 2018, 12th of March 2018. So we're 2 years into that, and the people in our office who work in that team, I think they would say that decisions are being made differently to the way decisions were made before, and also, but it has been a long process with that piece of legislation too. I think, all I can say is I encourage people to embrace what's good about the legislation, about the philosophy.
Thank you, Claire. So I certainly encourage people to send in some questions if you have any questions at the moment. So I might get Emma to turn her mic on, and I think we have one question so far from an audience member. So we'll answer this question, and then I might throw to Megan as well with a couple of questions. So Emma, floor's yours.
Thank you, Hilda. Karen from Carers Victoria has asked, how long do VCAT orders last for, please?
Yes. Okay, so as you might be aware, it's been fairly standard practice for VCAT in the past to make a guardianship order for 1 year or to make an administration order for 3 years. So that's a sort of practice that the tribunal got into, arguably because a guardianship order, the work of a guardian might well and truly be wrapped up in a year, and there's no need for it to continue beyond that time frame, whereas sometimes with administration it may be that inevitably the administration order is going to be renewed. So it's always been possible for anyone to seek an earlier reassessment than that time frame. So in terms of what the new legislation says, it's essentially what the old legislation said, except with one key point of difference. In the principles of the legislation, where it refers to the Convention on the Rights of Persons with Disabilities, it then goes on to say, if a guardianship order or administration order is made for such persons, then VCAT needs to set safeguards and appropriate limitations on the powers of guardians and administrators, and to review these orders regularly. So it doesn't define regularly, but and Megan might be able to jump in here and say what, in her observation, the practice has been so far. My guess is that the tribunal's unlikely to depart too much from that prior practice of 1 year for guardianship, and she's nodding, and 3 years for administration. But that's not to say they're still very early days, and early days clouded by the difficulty for the tribunal in conducting hearings by telephone. It might be down the track, and certainly when we conduct an investigation or where the guardian and the matter's due for reassessment at VCAT, we don't necessarily seek the orders to continue if we don't think they need to, or perhaps for a shortened time frame. So that certainly is advocacy that comes from our end. So if you're an applicant for an order, you know, and you think the order was only necessary for a short period of time, then say so. 3 years is a very long time for someone to be subject to administration when they're not happy about it.
Absolutely. And the other thing to remember is that orders are restrictive. They are certainly a restrictive intervention.
Perhaps
Emma,
if I can just, sorry, before Emma goes on, maybe, because I think there's a second part really to that question that's perhaps more important than the duration of the order, and that is the wording of the order. So the orders, rather than, and I'm not suggesting VCAT did this as a matter of course, but you know, the idea that you just get an order with lots of powers, each decision-making power in the order needs to be justified. So for a guardian to be given powers, there need to be decisions that have to be made, and each part of the criteria needs to be considered. So I would expect that we would see less wide-ranging guardianship orders over time, or perhaps more specifically tailored guardianship orders. And we have seen a couple of those so far.
Good. Emma, another question.
Thank you. Tanya's asked, what happens when the VCAT directive and the Act say opposite directives? And I'm guessing along with that, there's the question about the two acts, orders made under the two acts that might create some confusion for people.
Okay, well, I might be misunderstanding the question, but one of the things that the guardianship list at VCAT, of course, is often dealing with applications that traverse a number of acts. So you might, as an applicant, you might apply for power of attorney to be revoked and an administrator to be appointed. Maybe you're looking for the appointment of a medical treatment decision maker to be revoked and the appointment of a guardian to be able to make medical treatment decisions. And if you're doing that, you've now involved the tribunal in exercising jurisdiction under the Medical Treatment Planning and Decision Act, the Powers of Attorney Act and the Guardianship Act. As I sit here at the moment, nothing springs obviously to mind, which is an obvious contradiction, but sometimes it's just the nature of legislation. It has to create lines, you're in something or you're not in something. And certainly we've got one, I can't go into the details because it would be exposing of the person who's subject to this order, but it was a complicated matter because part of the decision was under the Medical Treatment Planning and Decisions Act and part of the decisions under the Guardianship Act. Makes it a difficult process, but these are matters most likely that will be dealt with by our office. So look, sorry, I may not have understood the question that's coming from someone, but it's just the nature of law that there will always be things that are open for interpretation. Ultimately, it's VCAT that has the responsibility to interpret. But the other part that maybe the question is coming from is, what if a person already has an attorney for personal and financial matters? Can VCAT still appoint a guardian or administrator? And the answer is that they can. They don't have to revoke or suspend the power. If, for instance, my mother appointed me to be her attorney for personal matters, but maybe there's some reason why I'm not the right person now to be making a decision about her accommodation, VCAT could appoint someone to be the guardian to make accommodation decisions, and then as the attorney I wouldn't be able to make that decision, but the other parts of the attorney would be left intact. So there are ways around some of these issues that might present.
Okay,
thanks Claire. I was thinking related to that workers may be seeing some of the orders made under the previous Guardianship and Administration Act, and that might be something that people would be interested to know about if they're seeing an order that's been made under the previous act.
Okay, yes. So the dilemma with legislation is it can't really create a ground zero. They couldn't on the 1st of March 2020 just say all the orders that have been made before that are effectively made under the new act, because the people who attended those hearings, they were told certain things. So we've got a two-tier system until we don't, which means that any of the orders that were made by VCAT prior to the 1st of March this year, then essentially the provisions of the old act apply. There are some provisions of the new act which apply. I'll come to one in a sec. But if the orders were made after the 1st of March, then you're bound by the duties and the principles under the new act. So yes, it is confusing. If you're dealing with someone who says they're a guardian or an administrator, you should always ask them to produce the proof, the piece of paper that says that they are, that gives the powers that they have, that indicates whether or not it's still in place, because people are often very confused about this, or indeed might be mischievous about what they purport. So you should cite the order. And so one of the key dates in your own head you need to be clear about is it prior to the 1st of March or after the 1st of March? So in due course, this two-tier system will grind to a halt eventually, because the guardianship orders bit by bit, because most of them were made for 1 year. Sometime next year there will be very few made under the old act. Although last year VCAT made one 5-year guardianship order, so there might be a few that tick on for some time. The administration orders will go on longer. So these are points of confusion, because you might have a guardian who's making decisions under the new act and an administrator who's making decisions under the old act. It all depends upon when the orders were made. Sorry, and there was something I was going to come to before I've forgotten, but I might come to me later.
That's okay. And then when we'll have a conversation with Megan, she might draw some of that out. It's sometimes a very confusing space. Samuel, we'll take the next question. Thanks.
Oh, sorry, I did remember. It's an important point, actually. So the distinction between the old act and the new act. So some of the provisions of the new act do apply to the old orders. Significantly, the issue of compensation. So some of you will be aware that under the Powers of Attorney Act, there's the ability to go to VCAT or the Supreme Court in relation to compensation actions for attorneys for personal and financial matters. And there have been quite a few matters at VCAT in relation to compensation about attorneys. And the Guardianship Act brings those provisions into line. So it doesn't matter when the order was made, the issue is when do you say the loss was occasioned. So you can't claim compensation at VCAT for something that happened before the 1st of March. It needs to be something that you're saying has happened since this act commenced.
Great, thank you.
Next question from David is, what if it is another person, for example, a parent, who is exercising control over our client and actively preventing them from exercising their will and preferences?
Yes. Okay. So there can be some very well-meaning parents of adult children with disabilities but they may not necessarily always, some will, but not all will necessarily be persuaded by the human rights discourse we're talking about at the moment, because they're very protective. They've had reason to be protective through the young years of their child, and they've continued in that fashion. So I suppose the thing is that what people need to understand is that you never have authority to make a decision for another person unless you have lawful authority. So if I'm the mother of a child with an intellectual disability, and they've just turned 18, then it would be the same as if I had a child who didn't have an intellectual disability who's just turned 18. They make their own decisions. And in fact, even before 18, if they have the capacity to make various decisions, they make those decisions for themselves. And for people who are parents, that might all be very terrifying, the decisions that their young adult children make. But here we all are, having survived our youth and young adulthood, and we are who we are because of the choices and the decisions that we made. So I suppose how you challenge someone is to get them to see that whilst they care, they may not necessarily have the lawful authority to do what they purport to do. Being a parent of somebody over the age of 18 doesn't give you lawful authority. So then the question arises, well then, does somebody need lawful authority to make decisions? So if you're dealing with a parent who you think is behaving in a way that is not promoting the human rights of the person, then they're the times that you might need to think about applying to VCAT for the appointment of a guardian. But I think, you know, we don't want parents who are well-meaning to feel punished by this system. You know, we want people to understand the ethos of it. And so I think spending some time with people and trying to provide some education would be definitely the first starting point than launching into litigation. It's the same as, you know, if some parents of young adults with disabilities are protective, then many middle-aged children are very protective of their aging parents. And we don't have rights to make decisions about our parents. We can't decide it's time for them to go into aged care. It's not for us to make those decisions unless we have lawful authority. And if we've got lawful authority, we need to produce a piece of paper which says so. And then we need to make decisions according to law. And so one of the resources, or two resources we have, one's about it, and quite detailed ones. One's about administration, and that's a co-production with state trustees, and one's about guardianship. That's a sole publication of our office. They're very detailed, and I think it would be perfectly reasonable that if you're dealing with a guardian or an administrator, to say, well, have you read this publication? If they've agreed to take on responsibilities, powers, with power comes responsibility. It's not just about having power. The Act sets out duties, and people need to meet those duties. And if a person doesn't have lawful authority, and you think they're effectively making decisions that impact upon another person, that's the time to think about making an application to VCAT.
Thank you, Claire. Next question.
Do you think that support coordinators have a role to play with this new focus of the legislation?
Yes, that is a great question. One of the groups we have in our office, I raised that with the person who was facilitating our group, because I thought about our discussion about supportive decision making, because it seems to me one of the creative ways of doing things is try to build into a person's NDIS plan that they get practicable and appropriate support to improve, to create the conditions in which they're likely to have decision-making capacity. It seems to me there's a natural synergy between these principles and the NDIS Act. Now, there would be other people who are better informed about this, but I think there might be a line item in the NDIS pricing manual, you know, the things that they will fund. But again, maybe perhaps we'll get, if Megan's got any experience of that within the casework of the organisation. But I would encourage people to be using NDIS as creatively as possible for these very reasons. One of the principles of the NDIS Act is meant to be that when people are funded for various things, that in due course they'll need less funding. And if one of the things we want is for people to be more autonomous and independent, then providing resourcing and supporting for people to have the capacity to make their own decisions surely is not only great for them, but is going to be of benefit more broadly to the community.
Thank you. Thanks, Claire. Emma, next question.
Now, this is going back to the earlier question that Tanya had. She's just clarified that her question related to VCAT having stipulated the bank account must be in the person's name, and the NDIA said no, the nominee's name. So while it's a specific question, I guess around that interplay between guardianship administration and National Disability Insurance Scheme.
Mm-hmm.
Okay, well that's a bit of a difficult one because obviously I don't know the background to that particular matter, but just from a legal perspective, I guess the dilemma is NDIS legislation is Commonwealth legislation. VCAT, what we're talking about here is Victorian legislation. A constitutional principle is that if there's conflict between state and federal legislation, then the federal legislation prevails. So all those matters get a bit confused, but sometimes it might be that a tribunal member needs to be given sufficient information. I'm not saying the member got it wrong on this occasion, I don't know, but the members can't be experts in all sorts of things. They will make orders based on what they know, and if you're a participant in a hearing and you've got information, it's good to put it to the tribunal, or indeed if you think they've made the wrong decision, ask for a rehearing, or if you want some clarity about their reasoning, ask them to provide written reasons. When members have to provide written reasons, it certainly sharpens the jurisprudence, and it's very helpful for our office. I read all the decisions that are reported by VCAT. There've been about 40 this financial year. I read them all. So I would be happy if people ask for more written reasons. It creates a jurisprudence for us.
Next, in the case that a person with a disability wants to revoke a guardianship application, how would they do so? Does an organisation have to do this on a person's behalf?
No, it'd be great. If the person wants to do it, let them, encourage them to do it and support them to be able to do it in a way that's actually going to be effective. Any person, they can certainly apply. And in the past, and I don't know whether it continues to be the practice of VCAT, they sometimes asked, if a person was asking for an early reassessment, the represented person, that they produce medical evidence that they no longer had a disability or lacked decision-making capacity. I think that's probably a pretty challengeable view, but if a person just keeps asking VCAT to revoke it, but they're not producing any new information to the tribunal, they're probably not going to get the matter heard. So I think if you can go through with that person why they think the order should be revoked, on what grounds, and if it's because they say, well, I don't lack decision-making capacity, they probably will need to produce some different evidence because the tribunal's already made a finding on that point. Or if their view is, well, I don't need an administrator anymore because ... Like if you can try to get them to understand which part means they don't need a guardian or an administrator anymore, then great. I mean, support them to do it. That'd be great. I don't think it happens that, I don't know that it happens that often.
I'm just going to step in there. So Emma, we might take the question from Anthea and Ruben. We'll take those two questions for Claire. And then the final question, which is from an anonymous person, I'm going to direct that one to Megan. And we also had a hi from JB, which is very nice. So we'll take the next two questions. The first one from Anthea. Thank you.
Anthea asks, as an advocate of older people who are subject to guardianship, how could I support my client to obtain a copy of the VCAT order?
I would have thought you can just call the registry and they would provide the order. Yes, it's a matter of public record. So whilst VCAT can't publish proceedings, whilst no one can publish what happened in a VCAT hearing or, you know, who the people are, the making of an order is a matter of public record. So I wouldn't have thought there would be a problem with contacting the registry and asking for the order. But
And from Ruben, what is the advice to support coordinators when a family member appears to be acting against the will or the best interest of the participant?
Well, I suppose it depends what we mean by acting against. Our office is constantly engaged with dealing with family members who, in our view, perhaps aren't promoting the human rights of people. Otherwise, you know, we probably wouldn't be involved. So that's very familiar territory for us. So I don't know that there's one answer. I think there's lots of strategies, and some of it might be about education. I suppose my approach to people is to start off by assuming they're well-meaning and have good intention, because I think most people are, and if people's human rights aren't promoted, it's not because other people are evil. But there is a spectrum, and there's a level at which people are more on the abusive spectrum, and that requires a different sort of strategy. So I'll just use the age-old friend of the lawyer and say it depends. Depends on the situation.
Okay, thank you, Claire. Now, there are still a couple of questions in there that we will come back to, but I thought I might just now introduce, of course, Megan. Megan, thank you for waiting there so patiently, and I'm sure you've been listening very attentively to all those discussions and questions, but this is a lovely segue for you, I guess. One of the questions, as this was one of the questions that I had for you, given that you are in the role of principal advocate guardian, and now we're going to shift a little bit into some of the practical applications of this act and what it means for our staff and also for the wider community. So one of the questions that we have here, and this is going back to will and preferences. So do you have an example of how will and preferences has been used in a particular case?
That's, I guess, a fairly broad question, and I would like to think that as we've gone on to explore what the new Act looks like and how our application is going and how we're progressing, I would like to think that every single new Act that comes along, every single new matter that OPA is appointed as a guardian for, we absolutely are exploring will and preference. So in general terms, the Act requires us to consider a number of things, and it's not just all about will and preference. There's a lot of things that we need to be considering. So in a very simple way, obtaining someone's will and preference is just starting with questions. We start with asking people questions and we just go from there. So it's no different from what anyone as a social worker or anybody in the community should be doing. We start with questions and we just progress and use the legislation to back us up and somewhat direct how we're engaging with people.
Okay, and so before this legislation came into effect, I think, you know, there may have been a mindset of advocate guardians being substitute decision maker. And now we're moving more into, I guess, the supported decision making framework or paradigm. Is that a significant shift for your practice? Have there been really big changes in the way you now have to work with clients, but given also the fact that in a pandemic and being unable to see clients?
Yeah, it has made a difference, and it should have made a difference. Claire talked earlier about a number of the acts that have changed as we've gone along. 1986 was a really long time ago, and when the new act, the old act was made in 1986, that was groundbreaking. We were and I haven't been at OPA quite that long, but some time, and we talked, you know, even through the term of the old act, we talked about how that act was in place because we had a really paternalistic approach to people with a disability, and that old act was around deinstitutionalisation. And I think there was, particularly in the early days, there was a real rescue mentality, and there was a space that guardians stepped into as substitute decision makers where we were given authority and broad-ranging authority to make decisions for people. And as societies moved along and people's understanding of people with a disability has moved, so rightly has guardianship legislation. In the old Act, when it first was made in 1986, there was a lot of people with a disability hidden away from our society living in institutions. Now, with deinstitutionalisation and a greater acceptance of, not a greater acceptance, a greater experience for everyone of people with a disability living in our communities, we're starting to think about it differently, and we're moving away from the paternalistic model of substitute decision making. So substitute decision making assumes that the person with a disability doesn't have any capacity to make decisions for themselves. And there are very few people in our society who can't make any decisions for ourselves. And as we've noticed and we've talked about earlier, there's a spectrum. People about how people can participate in decision making for them. So the new Act looking at supported decision making assumes that the person with a disability can make decisions, and that the role of the guardian is about working as hard as we possibly can to find out for ourselves and for everyone around that person how we can best support that person to be involved in their own lives and making decisions for themselves. Absolutely, there will be times when the person, either through their level of disability, that complex decisions are too hard, but we're on a spectrum. We don't start with an assumption that people can't make any decisions for themselves. So it is changing. It is absolutely changing. And the thing I'd like people in the community to think about is that at the moment we're talking about how that applies to circumstances when a guardian's been appointed. What I really want people to talk about and to think about is how this framework that is set out in the Acts with human rights as the focus applies to how you as a person, either in your workplace or in your home life or however, engage with people with a disability. That the focus is not about decision making for someone. The focus is about is how is that person participating in their life and how are we supporting them to do it. But yeah, that will have complications along the way.
Yeah, because I know for myself, one of the things that I really like about this legislation is that the presumption of capacity is there. That is your starting point rather than the other way round. But given that, so I'm talking about will and preferences, there's also a section in the Act that does say that there are times when those will and preferences can be overridden by a guardian, and that would be around serious harm. Now, I tend to think that we all live our lives as we choose, and there are risks, of course, involved in everything that we do, even if it's just, getting in the car and driving down to the shops. That's a risk that we take. So, and people with disability, of course, should be able to take those risks as well, like we all do. So can you talk a little bit about that serious harm element and when will and preference may be overridden, and if you've got any example of that thus far?
Sure. The two biggest things that come out of the legislation, absolutely, are will and preference and serious harm. Or it's the things that people have picked up the most. When we're looking at will and preference, there's a range of things that I like to think that as an office we've been doing for years anyway. That I hope, and everyone who is either a guardian now or has been a guardian in the past or into the future, it's really, really important to work out what is important to the person with a disability and to encourage them to be able to articulate that to their best ability. So as we work through the legislation, one of the first questions that the legislation asked us to consider is whether or not the person can make the decision themselves. So we get a little distracted about will and preference because the legislation wants us to firstly think about, can the person make the decision for themselves? So that's something that I would encourage everyone who's in the audience and everyone who's thinking about making an application. Can the person with a disability make the decision for themselves with practicable and appropriate support? And that is wide-ranging. What does practicable and appropriate support mean? It means thinking a little broader. It means thinking about whether or not there are communication tools, whether or not there is a time of day that the person is able to communicate best. You know, some people are clearer in the morning, some people are clearer in the afternoon, some people are better to have eaten, some people are not, a range of different things. So before we get to will and preference, I want people to think about what decisions people can make with support. So for some people, that's about, do you need to go and ask a family member? Do you need to go and ask the staff at the house where somebody might reside? Do you need to go and ask the person who they work with? Do you need to ask a range of people about, can this person with appropriate and practicable support make the decision for themselves? And as a guardian, our responsibilities are no different from the responsibilities pretty much as a social worker or as a practitioner or as working in a house. These are the things that should be guiding us when we're thinking about decision making with the person with a disability. So what can we do to provide support for that person to make decisions for themselves before we even think about will and preference and before we think about making an application for a guardian? So ideally, we can use practicable and appropriate supports and identify if the person can make the decision themselves. For us as guardians, if we've formed an opinion that the person can't make the decision themselves, or if the person, someone who's a social worker in a hospital believes the person can't make the decision for themselves with support, then we start to talk about will and preference. And I would encourage people to think about will and preference before making an application, because this is what's going to guide the guardian when they come along, whether they're a family member or whether or not they're an OPA guardian. So when we talk about ascertaining will and preference, it's again going back to all of the people, to the person with a disability, and asking them. We ask them, what is it that you want? This is the decision that I'm being asked to make for you. This is the thing that I would like to talk to you about. For sometimes it's about accommodation, sometimes it's about where the person will live, sometimes it's about other people in the person's lives who people are concerned about. What is it that the person with a disability wants? When you discharge from the hospital, where is it that you think you might like to live? When you think about which day activity you're going to go to, if we've got these two, which one is it that you would like to live? And it's interesting when we talk about will and preference and support and those sorts of things, particularly when we look at people who are in our aged population who have had a change of circumstances. They've been at home, they've ended up in hospital, and people around the person, through the practitioners and everyone else who's involved in the person's life, says, your circumstances have changed or you weren't doing so well at home. We need to think about what discharge looks like. And sometimes we're asking people to imagine whether or not do you want to go home or do you want to go into aged care? People may have never gone into aged care, never been in a facility, never imagined what that looks like. Or we're asking family members to say, do you think mum would like to go into a nursing home? I don't know. I've never been to one. All I've seen is all of the awful stories on the pandemic, about disease, and we need to think about things. And that's about, when we're looking and talking about will and preference, we're talking about people having enough information to actually be able to articulate what their will and preference is. So that's what I would really encourage people to do as a first step, is to gather the information that will assist a person to be able to actually express their will and preference. They might not be able to make the decision for themselves and it might be too complicated. And we need to accept that, and that's okay. But we need to then go down the next step, in which is about ascertaining the person's will and preference. Give people enough information, and we are a long way down the path of ensuring either that there are less applications made, so less times that we take people's human rights away from them, or if we have taken people's human rights away from them and there is a guardian appointed, that we're making sure that the person remains the focus of whatever decisions are being made. So difficulties during a pandemic, a zillion, I would say. as we had 3 weeks to try and get our head around new legislation as the pandemic hit, and we, like everyone else, not everyone else, like a number of people, particularly those of us working in offices, got sent home. We had to think about how we would ascertain will and preference. And interestingly, I think whilst it's been really hard, it's actually been a little bit of a benefit to us to have to make us think more broadly. The office is full of all of us saying, well, if I can't go out and see the person, I can't possibly ascertain their will and preference. And that's always been our default position, which is to go out and talk to someone in person, often on their own. And then the pandemic's hit and we've all had to say, actually, there are a range of different ways we can gather information. And so for me personally, I've shifted the way I engage. I've probably spent more time gathering information from other people around the person. I have spent more time texting with my younger clients, which has been a fascinating process for me. I would previously have gone out, met with an 18-year-old and talked to them about where they wanted to live and why they may have been in an abusive relationship and a zillion things. And I'm there 9 o'clock in the morning saying, let's chat. Now, luckily for me, I turned my phone off. Now I get text messages at midnight saying, my boyfriend's saying he wants to do this or I want to do that. So I've thought about it. It's been a bit of absolutely, it's been a difficulty and a challenge in the pandemic, but it's made a lot of us think differently. And that hasn't been solely a bad thing.
Okay. Yeah. So it is all very interesting. And I know it's still early days yet, but do you have any examples of where perhaps a will and preference was overridden but based on serious harm, and just an example of what that serious harm might have been to the person?
So one of the things that I will just slightly detour with is that our legislation has always allowed for there to be guardians appointed in what we would consider to be urgent circumstances that general community would call an emergency. That someone's at home or something's happening and there is an emergency and we need to have decisions made quickly. So the legislation for urgent decisions is different and talks about harm. So a guardian can make a decision in an urgent situation about under legislative authority for urgent, addressing just harm. When we're talking about serious harm and decision making for guardians, there's a lot of work that needs to go into thinking about what serious harm means, because it means a different thing for different people. So my version of what I think is serious harm is going to be different from somebody else's version of what I think serious harm is. And I know people have touched on earlier about what happens when you're a parent of someone with a disability. My version of harm for what I consider to be concerning for my child with a disability is different from what somebody else thinks is a concern for my child with a disability. So as guardians and as anybody working in this field, we all need to be mindful of what our own worldview looks like. What are we bringing to the decision making? What are we thinking about? What is our tolerance for making sure that the person with a disability is living their life as fully as they want to, and being aware of risk and what risk means. So in a really simple example of where we've overridden someone's will and preference for serious harm, I won't discuss an exact case. It'll be a bit of a kind of conglomeration of a number of cases. So in my role as principal advocate guardian, what is happening at the moment is when any advocate guardian who is appointed through the VCAT, who's an OPA advocate guardian, needs to override someone's will and preference because of serious harm, they come to speak to either me or a number of other senior people in the office. And we've chosen that because we think it's really important. It's really important that if we're overriding someone's will and preference, we're taking it seriously and that we're looking through and we're talking through. And so this is a decision the office has made to ensure that we're not just going back to a best interest framework, that we're articulating for ourselves and generally for others in the community, what does serious harm mean. So the case example that I will use is a man who was living at home with a partner. The partner, and he has dementia. The partner has passed away. The recommendations from the hospital is that this person is unable to attend to their own personal care at home. That if they were to return home, that they would be unable to attend to their personal care. They will be unable to ensure that they are providing themselves adequate nutrition and hydration. The person is at risk of wandering. The person is unable to articulate, basic sort of emergency procedures, such as knowing how to take care of themselves if they were injured or how to call 000, those sorts of things. So in those sorts of circumstances, what a guardian needs to do is they need to talk through what the initial decision they're making is. So the decision that they're being asked to make is what will happen when the person leaves the hospital. So there's a couple of elements of that is, will the person go into care or will the person go home? Now, sometimes we, as guardians, come along and the assumption from practitioners and people involved in that person's life and family is that the person couldn't possibly go home, that in no way known could the person go home. As a guardian, we have to work through all of the things that are going on in that person's life to establish what the serious harm is. So let's take that sort of scenario as an example. The guardian needs to talk to the person, whether they can make the decision for themselves. And then if they can't, they've expressed will and preference. The person says to me, I want to go home. I've explored with the person, what does that mean? This person is pretty determined they're going home and they're not going to let anyone come in and help them. That they're going home, it'll be fine, I looked after myself, it's all fine. So I need to gather information about what serious harm might occur to that person. And I need to just do a bit of a litmus test on it. I need to ensure that I've questioned whether or not for that person, are there other ways that they could go home? Does the person have enough money either in a package or in their own finances to support them to go home? When we talk about going home, is the person with a disability talking about the same place that we are? Are we all on the same page? Are we all thinking about those sorts of things? So in that scenario, the serious harm that would occur to that person would be a likelihood that they will experience a decline in their physical health because they are unable to attend to their nutrition and hydration and their personal care. That the serious harm is one of the other concerns is that if there is an emergency that the person isn't going to be able to attend to an emergency, can they call 000? If the person is likely to wander, what serious harm would occur to that person if they were to wander? Do they wander? Have they got a history of wandering on the streets? All of those sorts of issues. So in that scenario where the person does not have the supports to provide adequate care for them at home, absolutely I need to think about whether or not that is serious harm and whether the return to those circumstances cannot be alleviated in any way, and that I may have to override that person's will and preference to because of the serious harm that would occur to them if they were to return home and I didn't override their will and preference.
Yeah, thank you, Megan. That is a very common scenario too, the one about the person being able to return home. Okay, so Emma, I might invite you to come back with your mic, and we have got quite a few questions, and I'm going to open it up to Claire as well here for some of these questions. They're all very different, and some of them quite detailed. So Emma, I'll hand over to you for the first question.
Thanks, Hilda. What are the main things that you look for in a neuropsychology report to VCAT? Have the things that VCAT is looking for changed since the new Act?
I'll say something first, but I'm sure Megan can follow up. I spent most of yesterday reading a decision of VCAT. It's a very lengthy decision. It runs to 64 pages. And the significant part of that decision was about the member analysing 5 different pieces of medical evidence about whether the lady who is the subject of the proceeding, whether she has a disability and whether she lacks decision-making capacity. So it was a pretty fascinating read, because hearings don't necessarily go like this all the time, but, you know, very senior human rights lawyers acting for the relevant parties, 5 extremely senior people who'd conducted assessments. And so I was very interested to see how VCAT was weighing up that different evidence. So the things that I'd really suggest, if you are a person who provides a medical report, whether you're a neuropsychologist, a psychiatrist, a geriatrician, a GP, whatever, neurologist, whatever your specialisation is, the most important thing to be aware of is the legal definition of decision-making capacity. So one of the pieces of evidence that the tribunal member obviously was very pleased about was that the neuropsychologist who addressed the issue of whether the lady could make a power of attorney had been briefed by the legislative criteria in the Powers of Attorney Act. Now, that particular neuropsychologist had been briefed by our office to do the assessment, and that's the exact process I hope we would go through on a standard basis. So the thing really to understand is that in the end, it's a legal finding whether somebody lacks decision-making capacity. When the matter's before VCAT, it's VCAT who decides. Different medical experts can have opinions, they can have evidence, but it's evidence that will be weighed up. So in this case I was reading about, and it's not the first time I've looked at decisions where the tribunal needed to weigh up competing information. 3 pieces of evidence suggested that she didn't have decision-making capacity, and 2 said that she did. And the tribunal member had to determine which they found the most compelling piece of information. So I would suggest, if you're conducting any sort of assessment, you need to know what the legal criteria are. And you need to make sure that you're not coming across as if you are biased in some fashion. So if you've been briefed by a particular family member, the family member might have a bias, but you, the professional, shouldn't. You know, the medical people are the experts in which tests are appropriate to which circumstances. So none of us are going to tell you any of that, but things are challengeable, and the place and time of assessment is really important. And I think Megan alluded to this a little bit earlier about the best time to meet with someone. So it's not just that an assessment's conducted, but it's conducted at a time when the person's most likely to be able to participate in a meaningful way. So if they're not good early in the day, why would you be conducting an assessment early in the day? If there are issues of privacy, why would you be doing it when they're in a hospital bed surrounded by other people and they're embarrassed? Have you got an interpreter? Are the hearing aids working? Have you given them sufficient time? So all of those things about the time and the place of assessment, those things are all really important. Is VCAT looking at the issue differently? They have to look at the issue differently because they've got different legislative criteria. So under the old Act, to appoint a guardian or an administrator, VCAT needed to be satisfied that the person has a disability, and because of the disability, they're unable to make reasonable judgments about circumstances. That was a formulation of the past, and the formulation now is that the person lacks decision-making capacity, and that's defined in the Act. So they've got to go through all those components. So really, I would suggest if you're doing an assessment, you need to have Section 5 of the Guardianship and Administration Act open in front of you and to step through it. And in fact, we did a training session we had at the office sometime when we were in the office, late last year, I think. One of my colleagues went to a meeting and she reported back on it that all the professionals, health professionals, sat around the table and contemplated whether or not the person in question lacked decision-making capacity. But the only person in the room who looked at the legal definition was my colleague, and she did that because I told her to. So she took the Act with her and she had it open to Section 5 and she went through it on that basis. And so whilst you might think in the pecking order, a neuropsychologist has got more expertise in making these assessments than an advocate guardian who doesn't have those sorts of skills, I would suggest that the VCAT member would give quite considerable weight to the anecdotal observation of a person who's bothered to look at the definition in the legislation. So that's your starting point, and you can't deviate from that. And the other issue too is, does the person want to be assessed? Are they there willingly? You know, what's their resistance about the whole thing? So, you know, these are all quite complex matters, and how current is it? I've seen, so I might have probably gone off point here, but, you know, one of the problems with the system in the past has been that people might have been made subject to administration orders on the basis of rather flimsy evidence from the 1980s, which hasn't been updated to current attitudes. So there is great sophistication in what neuropsychologists and geriatricians and neurologists are doing about understanding this issue of decision-making capacity. It's a vastly evolving field. It's very complex.
Thank you, Claire. Emma, can we take the next question?
Yes, also around the issue of capacity. In the acute hospital setting, we often see patients who may be borderline in terms of their mental capacity, but there could be safety concerns about the decisions they make from the wider allied health and medical team. Will this scenario endorse a guardianship application to VCAT?
Well, the threshold question is whether the person lacks decision-making capacity. So if VCAT considers a person has decision-making capacity, then the person is responsible for all the risks associated which flow from the decisions that they make. If they don't have decision-making capacity, it would be unfair that they wear the consequences of risky decisions, and that's why you need a guardian. So I appreciate the idea that there's this borderline category, but in the end, if you can't get off the fence, then you need to either refer on to someone else who will administer different tests or examine the issue differently. But in this case I was referring to just before, in one of the medical experts, the way he looked at, and I'll just pull out the Act, because by doing things this way rather than taking you through a PowerPoint presentation, we've not actually taken you through some of the definitions that you'll find if you do look at our presentations. But in the Act, the meaning of decision-making capacity is a person has capacity to make a decision if, one, they're able to understand the information relevant to the decision and the effect of the decision. Two, that they can retain information to the extent necessary to make that decision. Three, and usually in our experience, this is where the sticking point is, use or weigh that information as part of the process of making the decision. And finally, to be able to communicate the decision. So in this case I was reading yesterday, one of the experts spoke about with this lady that she had slightly impaired capacity to understand information, slightly impaired capacity to retain it, but significantly impaired capacity to use or weigh the information. And one of the expressions I think all of us use quite a lot is we talk about people who have a rigidity of thinking. You know, so you say to someone, well, your option is to live with your oldest daughter or your youngest daughter. And the person says, I want to live with my middle daughter. And you say, yeah, I understand that's what you want, but that's not actually an option. She won't put you up. So it's your oldest daughter or your youngest daughter. And she says, I want to live with my middle daughter. And it goes around and around in circles. Now that's rigid thinking. And part of what the judge looked at in this case and looking at some of the evidence was this idea of having agility of thinking is part of your ability to use and weigh information if you can't take it in. So for those of you who do, if you're a neuropsychologist, I think you have to read this decision. Yeah, It's hard. It's 64 pages. I'm not saying it's easy, but I think if it's what you practice in, if there's anyone listening who's a neuropsychologist, get in contact with Hilda. I'll send you the case, because I don't know. I think it's really important. It's really, really important, and quite rightly so, because it's about the evidence that VCAT relies upon results in significant impacts on people's lives. I used to do spend a year at VCAT working for Oprah as a duty officer at VCAT, and I did dozens of sessions with medical students who came in their third or fourth year. They come and they watch a VCAT hearing, and we do a little bit of a spiel for them. And I thought a generational opportunity exists for us to keep impressing upon these young students who will become doctors, to remember that in the future, if they're ever asked to assess somebody's decision-making capacity, and they're sitting in their office late at night and they think, here I've been asked to do this administrative thing I'm not being paid for, and they shoot something off and they don't give it a lot of thought, that actually impacts on somebody's life. On the strength of them ticking a box which says the person can't manage their finances, a tribunal member might rely upon that, and the person has an administrator. And so that's, so if you're going to formulate an opinion that the tribunal is going to rely upon, it should be formulated with great care and with understanding of the law. So I know, and I'm not the expert in this, I've read dozens, hundreds maybe of neuropsych reports in the years I've done this work, and so I see reference to tests and they're vaguely familiar to me, and I wouldn't pretend to be the expert in those, but I am the expert in the definition of the legislation, and you have to look at it.
Thank you, Claire. Next question, Emma, this one might be one for also Megan to consider.
Yes, so the next question is around where there is a guardian in place and the considerations for guardians, and how the various considerations need to be weighted.
So I think it's important to remember that the same criteria that apply to a OPA guardian apply to a guardian who is in the community as well. So if there's a family member who's appointed to a guardian, they are also required to consider the same legislative criteria. In relation to what carries the most weight, I guess that's pretty tricky to answer. When we're looking at overriding someone's will and preference because of serious harm, I guess we would be considering what are the likely outcomes. So does someone not having a shower for 3 weeks, does that cause serious harm? Not really, unless they're doubly incontinent and that's causing skin integrity issues. Does someone's inability to remember to turn the stovetop off and they create a fire, that's probably something that's going to weigh more heavily in decision making around what is actually serious harm and whether we need to override someone's decision. So it's absolutely case by case base, I would think.
Thanks, Megan. Next question, have you had any instances where the person does not want to take meds? How would this be resolved under a supportive rather than a substitute approach?
Do you want to go, Claire? Or
No, you go.
I don't actually know that I have the answer to that. I know that there is certainly within the aged care system and a range of different things, there are issues in relation to administering people medication subvertly without people being aware that it's occurring. The issue around supportive guardians is that the person needs to agree and want there to be a supported decision, a supported guardian appointed. But the role of the supported guardian is to assist the person to make decisions for themselves. They're not in a position to be making decisions on the person's behalf that is going to be against what they're expressing they want to do. So that's my interpretation. What's your answer, Claire?
Well, of course, I think we'd always be curious, why don't they want to take the medication? Maybe they've got a very good point. They might not like the side effects, or they might misunderstand the purpose of it. Anyway, there's any number of reasons people don't want to take medication. So I suppose understanding that's pretty critical. the issue of the administration of covert medication is something I'm interested in. I've never really been able to find any clarity about the ethics and legality of the whole thing. And I did listen to a webinar recently on this topic, which looked at it from health professionals' perspective, and that's perfectly legitimate. But the impression I got was that nobody really understands the legality of it, so we all just ignore it. And I think, you know, that is problematic. If you have authority to make a decision about medical treatment, and the definition of medical treatment includes the administration of medication, that was one of the changes in the Medical Treatment Planning and Decisions Act, then a medical treatment decision maker can make the decision. So I say, well, yes, my brother should, I consent to him having whatever the medication is, but who compels the medication is at a different level. So, I mean, that's often a dilemma for group homes and for aged care facilities. There's not really an easy answer to it from a substitute decision maker's point of view. But from a supportive perspective, it may well be the person who has rapport well and truly understands why the person doesn't want to take it and where they're coming from. It might be coming from a place of paranoia, something that's utterly unsubstantiated with medical science. What if you're dealing with someone who's been a lifelong anti-vaxxer? They've got a strong ideological view. You know, there are so many reasons. I'd really want to understand the person's reasons, because whilst personally I'm not an anti-vaxxer, if I was making decisions for someone who had been very involved and that had been a strong expression of all the choices they'd made all their life, why are we coming along at a point when they can't now give effect to those decisions for them to be disadvantaged? But then again, maybe the medication's going to have an impact upon them that if they were in a position to make a decision, they would have taken. So these questions, the breadth of human experience is, you know, it's limitless, isn't it? Like, this is why Megan's been at OPA 18 years and I've been there 15 years and Hilda's been there 5 years and will probably be there a while yet, because whilst we can't always come to straightforward answers, there's always a lot to contemplate thoughtfully to try to get to the best decision that we think we can.
Thank you, Claire and Megan. So, look, I'm conscious that we have been sitting here for a long time, and though we have still a few more questions, I'm going to just stop there. I do appreciate all the questions that are coming through. Some of them are quite detailed and long, and I would certainly suggest that you get in touch with the advice service for very specific case consultation or secondary consultation, because some of these situations are very detailed. And I do acknowledge that we haven't been able to answer everyone's questions, but we've done, there've been quite a few that have come through. So thank you so much for your participation. And I agree with you, Claire, there's still so much to learn, even though, you know, I'm probably one of the people that have been there not all that long, 5 years. So I still think, you know, I've got a long way to go still in understanding acts. And I don't know if you remember when I first started, I hated reading acts. I had no idea how to read an act. And I think I'm a lot better now. So, and that's been, of course, to a big thank you to all my colleagues who I work with. So I just wanted to stop there. Thank you all very much for participating today. It is a long session. There's a lot of information, so you might want to watch the recording again. I had a couple of questions of people interested in receiving that decision, Claire, that you spoke about. So I will send that out to everyone, as well as a PowerPoint presentation that does contain all the key things that we've discussed today, so that you can have a look at that at your leisure. As I said, there's plenty of resources on our website for professionals, so have a look at that. And also that following the session, I will also send you just a quick survey. I really welcome your feedback. This is only our second public webinar, so we really want to gauge how we're going and also get your ideas and comments coming through to us so that we can be responsive. Emma, I don't know if you want to come on camera, I want to say thank you to Emma for being our moderator today, Megan, our principal advocate, for your time today, and of course Claire for participating in this webinar. I know that you get asked to do a lot of these, so I really appreciate your time. And most importantly, thank you to our audience for joining us today. So we're all going to say goodbye from our various locations, and thank you very much for joining us today, and we hope to see you again soon. Take good care and stay warm. Thank you, everyone. Thanks. Bye.